everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc forum called the Antiquities Act, a tool for conservation or a law without limit. Speaking on the panel today, we have Harry Graver, who is an associate at Jones Day, and Professor Sam Kalin of University of Wyoming College of Law. Joining us as our moderator today is Jeff Bielert, who is a partner at Stein Mitchell and a member of the Environmental Law and Property Rights Practice Group. If you'd like to learn more about today's moderator or speaker, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Jeff, thank you for joining us today, and I'll hand things over to you.
Thank you very much, and thank you to Professor Kalin and Harry Graver for joining us today. As Edith mentioned, this is sponsored by the Environmental Law and Property Rights Practice Group, of which I'm a member. And the Antiquities Act, our topic of discussion today, I'd just sort of like to start with a recent case that's been litigated in the 10th Circuit. And our first panelist was on the legal team that briefed this case in the 10th Circuit. His name is Harry Graver. He's at Jones Day, as Edith mentioned. He previously clerked for Judge Wilkinson on the 4th Circuit and Justice Kavanaugh on the Supreme Court. Works on issues and appeals at Jones Day. Professor Kalin is a professor at the University of Wyoming College of Law. He is the William T. Schwartz Distinguished Professor of Law and Associate Dean. He's a co-founder of the school's Center for Law and Energy Resources in the Rockies, and previously served in the Solicitor's Office at the Department of the Interior during the Clinton administration, and has practiced many years before becoming a professor. He's published many books, many articles, and currently teaches environmental law, administrative law, legal history, public lands, energy, and Indian law. So thank you for joining us here today. So I guess just to start this off, Harry, maybe you could sort of walk us through what the Antiquities Act does, and then also sort of discuss the case that you are a member of the legal team that briefed it in the 10th Circuit.
Absolutely, yeah. Thank you, Jeff. Thanks for everyone for putting this together. So I guess we'll start. The Antiquities Act, it is an old law that is starting to be used in very big and novel ways. The Antiquities Act was passed in 1906. The impetus for it essentially was that a bunch of people were going out west and pilfering American lands of historical artifacts, relics, things like that. And federal law had nothing to say for it. So originally what happened is a group of archaeologists got together for the better part of about a decade, trading bills with Congress to figure out what to do about this problem. So they came up with the Antiquities Act. And I think a helpful thing is just here's the key text of the act. So this is what it was in 1906. It is what it is now. This is the key part of it. It says the president may, in the president's discretion, declare by public proclamation historic landmarks, historic and prehistoric structures, and other objects of historic or scientific interest that are situated on land owned or controlled by the federal government to be national monuments. Okay, I won't read it all again. But the basic idea is that objects of historic or scientific interest can be protected as national monuments under the Antiquities Act. What has happened soon after the Act's passage, but a lot in recent years, is that what constitutes an object has grown and grown and grown in somewhat novel ways. And that's kind of what brings it to our suit here, which relates to two monuments from President Biden out in Utah. They relate to Grand Staircase and Bears Ears. Now, both of those came from prior administrations. Grand Staircase came from the Clinton administration, and it was controversial from day one, so much so that Bill Clinton announced it from Arizona on its inception day, not in Utah. And then for President Obama, with Bears Ears, it came in his closing days in office. And these take out huge parts of Utah, about 3 million acres of land, which is about collectively the size of Connecticut or so. And what's interesting about this case is that it really tests the frontiers of what can be an object under the Act. In our suit, we identify 5 from President Biden's proclamations that are really the heart and soul of the proclamations, in our view. One is that he sets aside all of the land on the idea that the landscape itself is an object situated on land. And then there's 4 other sets that kind of fit the same bill. You have geographic regions, ecosystems, habitats, and animals. Those are sort of the things that we have in mind. And I think the key part of the case and the reason that it's important is it really tests whether the Antiquities Act poses any real limit at all. Because there's no inch of federal land that does not have at least an ecosystem or a habitat or is not grazed by some animal. The last thing I would say, just by way of background, so the procedural history of it is that we brought this suit alongside the state of Utah. So we represent a host of individual plaintiffs, folks that want to use this land. And the key thing is that once something's declared a national monument, it's pretty much shut off for all productive uses. So we have guys who are, one's a uranium miner, one's a rancher, one's an off-roading group, one is someone who wants to access these lands for resources. And they can't do that anymore so long as these monuments are in effect. And then we're alongside the state of Utah, which obviously has its own interest there. The district court kicked out our suit, and it held that monument designations are unreviewable as a matter of law. That's the first time that's ever happened. There's been plenty of Antiquities Act suits. What I'd say is none of them have succeeded, but all of them have failed on the merits. No court has ever held before that they're just, or no appellate court rather, or the Supreme Court has ever held that they are unreviewable as a matter of law. That was the main focus in the 10th Circuit a few weeks ago, is whether or not these proclamations can be reviewed by a federal court at all. We touched on the merits a little bit, but that was kind of a secondary issue. So that's all by way of background. The Antiquities Act and this case right now going on in Utah.
Appreciate that. Professor Kalin, I just want to provide you sort of a chance to introduce yourself, maybe give your views about this particular statute, maybe some of your experiences in what it does and what it's meant to do.
Well, thanks, Harry. I think you did a great job of sort of giving the folks an idea about sort of the evolution of the Antiquities Act. I guess in all honesty, or at least transparency, I was involved early on in the Grand Escalante because that's when I was in the solicitor's office. So I won't say anything, I guess, directly about that. But I think that a couple of important points to think about. When we begin to take a look at issues involving the Antiquities Act, the act has been used both by Republicans and Democrats historically. So I think there's a really good history of bipartisan support, if you will, for the use of the Antiquities Act. And in fact, a lot of the national parks, premier national parks, including one obviously here in Wyoming, have ultimately been designated or were originally designated as national monuments. So Congress too sort of has reflected on some of the designations and turned them into national parks. The other thing that's, before we get into some of the details, that's worth at least noting is that in a lot of the areas, what we have seen in terms of the scholarship and the economics is that in some areas, including one area here in Wyoming a long time ago, folks wanted it designated as a national monument, an area, it's a small cave area in Wyoming, in order to attract economic activity to an area. So we have seen, for example, even in King County, reports about how economic growth has occurred as a consequence of the designation. So I think it's important to appreciate that. And even when you had President Trump, while he decreased, it's important to understand the 2 monuments that we're talking about today. The Interior Department actually recommended that President shrink or abolish a lot more national monuments. They wrote a memo to President Trump, and President Trump only addressed those 2 national monuments. And President Trump also signed a bill, a very large public lands bill, which added basically new wilderness lands, monuments, and even wild and scenic rivers to the national system. So when we take a look at the questions that were being looked at today, I think really it raises 2 or 3 specific and some subsidiary questions. The first one is really, as Harry said, does any court really have the power to even review a proclamation designating a particular area as a national monument, or effectively, is the executive immune from the doctrine, or basically because of the doctrine of sovereign immunity? And, the second question is really if review is available. I think this is where Harry was going. If review is in fact available, what really is the scope or the nature of that review. And then there's a subsidiary question to that is really then what type of objects can be protected under the Antiquities Act? And does the act extend beyond, let's say, archaeological objects? And then, of course, really not in this litigation, there's a fourth issue or a fourth question, and it's really the outstanding dispute, which I don't think we're going to get into, but maybe we can, about whether a president can either abolish or even shrink a national monument. But again, that's not directly related to the pieces of the Dalton and the Garfield County cases that we're going to be taking a look at today. But, I think Harry might be a little bit shocked. I don't know. On the first point, there's probably a lot of overlap between myself and others. I don't see why there's not judicial review. I mean, obviously, the Administrative Procedure Act is not available. We all know that the APA waives sovereign immunity, and that's how you can bring cases against federal agencies in U.S. District Court, but that does not apply to the president. And in fact, the Department of Justice here has emphasized that, Congress has provided no mechanism for judicial review of designations of national monuments. Of course, that's not surprising, as Harry really portrayed. I mean, in 1906, no one would have thought about actually providing for a provision for judicial review. So the interesting thing is that, the question on scope of review and whether that can even be reviewed in the first place comes down to a really interesting debate for lawyers about what is the scope of the ultra vires doctrine that allows you to go after, if you will, let's say a presidential decision. And part of the debate is, can you only bring a case against the president when you're alleging constitutional violations, or can you bring a case when you're alleging a violation of a statute? The U.S. indicates that, we don't need to have any check on the president. And I'll agree with the U.S.'s position on what some of the checks are on a presidential decision-making process. And I was there early on in the Grand Escalante. There's no doubt there are checks. The deliberative process that the administrative agencies use when they go with the White House and talk with the White House about a designation of monument, they clearly are a lot more deliberative. They take a long time. Nowadays, you get petitions for designation of monuments. When I left, my former colleagues actually had to go out and walk and map the area. So there's a lot more care and they got caught in a storm, by the way, but there's a lot more care that actually goes in to designating a monument. It's not as if the president simply says, okay, I'm going to designate a monument, and then 2 weeks later, they designate a monument. So there is really a check on what the president does. The second thing is that, when the president acted in the Grand Escalante, obviously there was no really advance warning on Grand Escalante. It caught some people by surprise. Ever since then, and particularly with President Obama, we have seen presidents really engage, including with President Biden, really engage the public. So there's no surprise, which really was one of the controversies about the Grand Escalante to start with. The other thing is that when Congress passed the Federal Land Policy Management Act, or FLPMA, in 1976, there was some question about whether we should get rid of the Antiquities Act. And obviously, Congress made a deliberate decision not to get rid of the Antiquities Act in 1976. But I really want to at least underscore one point, is that I think Harry's right. I mean, there's been no court that has said they are completely immune from review. It goes back almost probably to Marbury v. Madison. If a president acts without any statutory or delegated authority, clearly there ought to be an ability to review a particular case. If a statute granted a president the ability to buy a house in, let's say, Wyoming, and the president bought a house in Montana, you're really going to tell me a court's going to say, oh yeah, the president can use federal money to basically buy the house in Montana? So I think where we probably agree is on that issue. Where we probably disagree is really on the scope of review and what you really can do. And I think the answer is whether or not, at least from my perspective, whether or not the president has at least plausibly made a case for why a particular area is a legitimate object of historic or scientific interest. And also plausibly, there's a subsidiary question that I think Harry is going to get into about whether or not the president has designated basically the smallest area possible. And, so those are sort of the key issues. And I'll sort of turn it back over to Harry. I mean, I can pick up on my details of those other issues, but, I don't want to go too long without going back to Harry.
Thank you. Well, I want to touch a little bit on at least the judicial review aspect of this before we move on too much further. But it seemed to me like the 10th Circuit during oral argument was sort of struggling with this issue, right? It sounds like the DC Circuit, maybe the district court in DC, there's been cases suggesting that you can challenge these sorts of Antiquities Act proclamations by alleging that it's an ultra vires act by the president. And it sounded to me like the 10th Circuit was struggling with, well, does that really get to the merits of the scope or the interpretation of this statute? Or, what does a plaintiff need to do to allege that sort of exception? And it sounded to me like not only was the court struggling with that, but it was also struggling with, well, what's the cause of action? And I wonder, the government points out in their brief, Congress, and I think Professor Kalin, you hinted on this, Congress never provided private party, an enforcement action. So Harry, maybe if you could address that. It seems like the 10th Circuit was concerned about that. Sort of what's your response to some of the things that Professor Kalin said, but also how do you fit within this sort of ultra vires claim? And then what's sort of the cause of action by which plaintiffs are allowed to bring these sorts of challenges?
It's a really important point. It was, as you noted, it was the kind of the main focus of argument in the 10th Circuit, because it's a really big, monument designations are a really big deal. And even if the president chooses to take in a lot of input, by the letter of the statute alone, he can just go out to the Rose Garden, shout it out loud, and you have a national monument. So the president's given a tremendous amount of authority here. So for it to go unchecked, I think that was the first thing that the 10th Circuit was just instinctually uncomfortable with. And I think this goes into what the professor was saying about kind of the types of review that are available. Because what's tricky about ultra vires review is like the word jurisdiction, it's kind of thrown around a ton. In all these cases, it gets very confusing very quick. Our core claim, though, I think kind of rests in the heartland, which is that when the president acts in excess of authority, when he does something he was never authorized to do in the first place, that is garden variety ultra vires review. You can look at Youngstown, for example. Does the president have statutory or constitutional authority to seize the mills? So when the question is whether or not you have the power to do X, that's sort of in the heartland. And what happens there is that when you act in excess of authority, you don't have sovereign immunity attached because you're operating as an individual. You're not operating as the sovereign's agent. So sovereign immunity never attaches in the first place. And then for a cause of action, it's longstanding equitable practice that when an executive agent operates in excess of authority and hurts you, you can go to a court to stop that action. So you can look at, there's an old chestnut case called McAnulty from 1902-ish. There's Youngstown, there's Dames and Moore. Even in the Trump immunity case, which obviously is not shy about the role of the president in our constitutional system, the chief said, if the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so. So that's our basic claim. Because what I was saying before is like, what we focused on is the monuments are based on things that are not objects. So you've set aside land to protect items that you never had the authority to do so. As the professor's touching on, it gets kind of a little bit more complicated based off of other possible Antiquities Act claims that people can make. And in fact, the state of Utah really pressed these in particular, and we joined those arguments, but they were, it was the focus of their brief. You can think about whether or not something is an object is a little bit more of a binary decision. Where it gets tricky is where the statutory standard involves some discretion. So is something really historic? Is something really scientific? Is it actually this? It's one other key piece of the act it was touched on is not only do you have to set aside objects, but you need to set aside the smallest amount of land compatible with their protection. How does a court figure out what's smallest? And how does that fit into ultra vires review? There is a little bit of a mismatch, and it's a little bit hard, and the DC Circuit struggled with this, as you noted, when it comes to sort of those discretionary terms and how that fits into ultra vires review. I think it's really hard to say that there's no review at all because Congress intended for those terms to be very meaningful limits on the president. And just to kind of write them out of the statute or to make them matters of the president's discretion seems to be sort of no limit at all. But I think it's trickier. With us, it's much more garden variety. It's you have a clear, concrete statutory term. Is something an object? And if it's not an object, you don't have any power to protect it under the Antiquities Act. And I think there we're much more in like the Youngstown territory than, you know, the Dalton and those sort of line of cases.
Okay. One of the things that the government pointed out in its brief was that Congress retains the authority to change presidential proclamations or to withdraw them, right? So this idea that, well, Congress itself has done this in the past, that a president may decide to set aside or to reserve land under the Antiquities Act, and that Congress then can come back and say, no, that was a mistake, or withdraw it, or that's sort of on the back end. And I think, Professor Kalin, you also mentioned that Congress also could look at a designation for a monument and decide, well, wait a minute, this actually is valuable land. We need to set it aside for a national park or national, there's some other designation that Congress can then decide. What do you make of that? That there's sort of this congressional oversight that's already sort of baked into a proclamation made under the Antiquities Act?
So at least our take was that, and I think this is a point that Professor Kalin was mentioning before, is it's certainly true that Congress has a role here, and it's played that role in the past. But that's, I think, also true with every statutory interpretation case, where the president can always violate a law. Congress can always intervene. That doesn't mean the courts have no role to play. But one part I just want, I think, helpful context here that's important is it's true that the presidents for a long time have used the Antiquities Act in increasingly broad ways. But President Biden's proclamations are still unprecedented. The key part of it is that they've set aside 3 million acres on the idea that landscapes are objects situated on land. And then there's this part of this troubling trend, which the Chief Justice flagged a couple terms ago in a separate writing, where you're setting aside all of these acres for what he called imprecisely demarcated concepts, things like ecosystems and habitats, things that don't have any independently discernible bounds. And when there are no independently discernible bounds, then it's just in the eyes of the president. There's no enforceable limit at all. The act quickly becomes a blank check. So I think the key part here is just that I think it's true, and it was a helpful sort of atmospheric point for the government, being like, this has been around for a while. Congress has intervened when it's been really excessive. They've blessed these practices before. But I think the point to emphasize is, at least over the last couple decades in particular, the act has really started to be abused in novel ways. And President Biden's proclamations are sort of chief in point with that, with the sort of land as object theory of the Antiquities Act. If that's true, then again, there's no meaningful limit at all on the Antiquities Act. You can set aside the entire West to protect a single bee. And on the president's view, that's both unreviewable and completely authorized by Congress.
So the only follow-up I have on that is a couple points. I think that we need to be careful because there really aren't that many challenges to national monuments. Most of the national monuments are not really ever get involved in litigation. So we're really talking only about a handful of national monuments that we've seen litigation on. So it's not like in other areas where there's been a lot of challenges. This is why the law is perhaps less clear in some of these areas, even on judicial review, is we just don't have that many cases. The second thing is that, Congress does have a unique ability. It's a little bit different than in other types of programs because the nature of particularly national monuments and public lands, the role vis-a-vis the executive in Congress, that's why President Trump signed that omnibus land bill. I mean, we have negotiations quite often that are unique that relate to our public lands and natural resources. So I think that the role of Congress is possibly a little bit different. And we tend to take a look at a little bit more of the interest of the state when we do designate national monuments. When it becomes a really controversial matter, and yeah, there have been a couple times when it's been fairly controversial. Those two instances, one was in Alaska with Jimmy Carter, and that resulted in specific legislation not allowing the president to basically go over 5,000 acres of a national monument without congressional approval up in Alaska. And obviously here in my state of Wyoming, we have a provision after what happened in Jackson Hole that basically says Congress told the president, no more national monuments in Wyoming. Now, Wyoming was the first state with a national monument. So, So Congress can act. And I think the other thing that's important to think about is the language does say discretion. And so there's no doubt that a court cannot review whether the president's acted arbitrarily, capriciously. It can't really review arguably a record because what record are we going to talk about? This is not a typical Administrative Procedure Act type case. So when we take a look at the scope of limited review, and I think this is why some of the law professors wrote an amicus brief, is it's very limited. So long as it's plausibly stated that the president has designated something that is either an object of scientific or historic interest, I think that's where the inquiry ends. But if the president were to designate, a parking lot that just happens to be at the Department of Energy's or the Department of Defense's lands owned by the U.S., that plausibly would be arguably reviewable and outside the bounds. So I think there are going to be some cases that might fit that problem with beyond the discretion, but the idea of affording immunity, if you will, to discretionary decisions, that dates back to Marbury v. Madison. If you take a look at the whole evolution, I think the McNulty case you even talked about, it's a mandamus type case. The court can issue basically equitable relief because the statute is clear. There's no discretion. And that's what Marbury v. Madison was based on, is the difference between being able to review an executive branch decision is where there is discretion, that's political choice. It's up to Congress to second guess it. Where it is not a political decision, but a exercise of clear statutory directive, that's where a court can enter and basically issue some sort of equitable relief. So.
Yeah, and I mean, it sounds like this act, the Antiquities Act, is actually broad. I mean, we talked about the language that the president has discretion. But Harry, I think I take your point to suggest that, okay, but that discretion is also cabined by the words around it, right? And we're talking about discretion for monuments, discretion for smallest amount of land that's going to protect this area of interest, or at least some object within that area, that the land that's being set aside is meant to be tied to something on the landscape, this object, this notion of an object. And I read the government's brief, and I think that the government identifies areas in which Native Americans were present, some of the archaeological sites, things like that are spread out throughout this area. And in fact, the government says, well, and we're not even going to identify all the others that are there because they're so precious that we don't want people tromping around and ruining some of these sites. I mean, what do you make of that? That the government, yes, we're going to identify and tell you that they're sprinkled out throughout this entire area, but nonetheless, we're going to designate 3 million acres. I mean, where do you see sort of the scope of discretion falling outside of what the act allows, at least in the context of this case?
So I think that, Utah did a very helpful thing in their complaint where if you took I forgot exactly what it was, maybe 300 acres for each of the identified objects, it added up to about 10% of the set aside land, maybe less. So the points that I was like, the objects that we really focused on, these kind of imprecisely demarcated concepts, really do the work in filling up all of the huge chasms of land in between all of those identified and almost certainly valid objects. On the discretion point, I think I might have a slightly narrower view of it, because what the Act says is the president may, in the president's discretion, declare by public proclamation, blah, 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 national monuments. I think he has complete discretion over whether or not to declare a monument. And that's almost certainly unreviewable. If everyone is saying you need to set aside 500 acres for so-and-so, the president chooses not to do it, unreviewable. I don't think he has discretion to say what the law's terms mean. And that's, and that's going back to the Youngstown, anywhere, as a professor said, from Marbury onward, that's the traditional function of the courts. I think that, again, and you can kind of see maybe parallels to this in like the world post Loper Bright about what role there is for courts in enforcing statutory terms. Because you can imagine differences between sort of concrete limits and discretionary terms. A good example is like in the presidential reviewability space, this old case called South Dakota versus something, South Dakota whatever, where there is a fight about a statute that gave the president the authority to control the phone lines during a time of war, if necessary. So the two key statutory terms were control and necessary. And the court parsed the two. What it said essentially is that, well, the necessary piece, that's probably unreviewable because that is kind of a pure judgment call. And we don't really have any law to apply here besides our own sense of things. And it's really inappropriate for a court to substitute its own judgment for that of the president's. So you have like, a wiggle word like necessary. But then they reviewed a challenge as to what the word control means, whether you can take the full phone line or just part of it or something like that. And I think that's what our case is that, there's certain parts of this that get harder when it involves judgment calls, scientific, historic. Utah has a lot of persuasive points on this, but it's different in kind still than something like object, which I think has just a independently discernible definition as just a matter of statutory interpretation. And I think here, as really any other statutory charge, the president doesn't have discretion over what that term means. And the key last thing I would just say on this is the Antiquities Act was, this was not kind of a passing legislative effort that was sort of tossed in at the end of one session. This was debated for 5 to 6 years. And members, the key constituency was members of Western states were petrified about the president getting a blank check to set aside huge amounts of land. And, to the extent it's relevant, the legislative history here is overwhelmingly clear. Everyone is saying, don't sweat it. This is going to these are small reservations. It's for just like the objects of antiquity. It's for all these relics getting taken. Don't worry. We're not setting aside your entire state. It's evolved towards that. And I think that the limits that we're emphasizing and the basic point that we're saying is that even if the president has discretion, Congress did not stumble into the one thing that they did not want him to have, which was a blank check. So I think once you reduce these independent limits, it's just like, well, those are judgment calls for the president. Then you have Congress fail at its one goal in a spectacular fashion. And there's no real reason, I think, to read the act that way.
And just as a sort of point of clarification, I mean, we're talking about federal land, right?
Yeah.
I mean, we're not designating state of Utah land. I mean, this is land that belongs to the federal government from the get-go. And I think in your case, at least, you have sort of individual plaintiffs that use this federal land, a rancher, a miner, whatever it is. Can you just sort of explain how does it change their use of the land? What does the monument designation do that changes what they could do with their land? Because I think that the government in response is suggesting, well, no, we've carved out all the exceptions that even though you have a monument designation and even though it is 3,000 or whatever, 3 million acres in this area, that you still are allowed to exercise your rights if you have a valid mining claim or if you have a grazing permit or whatever it is. Is that true, or is that something that the courts, maybe the 10th Circuit, might have overlooked?
So I think they picked up on it. And as we talked about at argument, the government insistence on that point, I don't think bears out. I mean, without getting into like the nitty gritty of it, just taking it 30,000 feet, the entire purpose of these monuments and the reason they were trumpeted as these huge deals is to prevent the very things that our guys want to do. So these are massive conservation efforts that will stop ranching, mining, off-roading, and the like. And then us, we're just like, well, we want to do the ranching, mining, and off-roading. And what happens just as like a technical matter is that usually the default for federal land, which is important to keep in mind, is majorities of Western states. It's huge percentages of Western states. Usually it's this thing called like a multiple use mandate. You keep it flexible. You have a bunch of different priorities. You allow for the productive use of land to be measured against conservation interests, but it's a balanced effort. Here, you put a huge premium on essentially conservation alone. So the idea that you're going to be able to pursue mining is non-existent. Ranching is strictly limited. Off-roading, you can see this in the management plans that have come out. Trails are getting closed. The expansion of trails are shut off. The basic idea is the character of these lands by design, by intent and design, changed dramatically. So again, the entire purpose for setting aside a monument is to curb certain activities. And, there's fights about that as a policy matter. But I think it's very clear that life will be very different on these monument lands if they're upheld.
But I think I would just add as a caveat, we have to understand that every monument designation has VER, valid existing rights language. So there are a lot of, for example, under the 1872 mining law, you know, if someone is staked and has a valid mineral discovery on lands, then the only difference, and came up in the oral argument, I think, the only difference is you might have a validity examination to actually make sure that they're legitimate mining claims. But other than that, it does not take away the ability to mine existing, if you will, mining claims. And, you know, the other thing that we've seen historically is that people come in and locate mining claims as nuisance value mining claims. So arguably what it does is it takes away people who just want to basically develop or locate nuisance mining claims to then get bought out. You know, so I don't know that it is as dramatic as Harry is suggesting. I mean, obviously, one of the things that we first saw with Grand Escalante, and I remember it in vivid detail, is people were claiming right away, you know, what was going to happen. And we kept telling folks, I mean, everyone kept saying, hey, look, we don't have our management plan. It's ultimately the management plan that's going to drive what decisions occur in a particular area. And, you know, even absent a monument designation,